important decision that just came down from the D.C. Circuit Federal Appeals Court. This is the higher court in D.C. It's one step below the Supreme Court. This is a 2-1 decision delivered by the court. The opinion is by Justices Justin Walker and Judith Rogers. And this has implications for a lot of January 6 defendants. That's really why I want to focus on it. So one of the January 6 defendants, a guy named James Little, was given, let's call it a double sentence. He was sentenced to prison, and he was also sentenced to a lengthy period of probation. Now, this is a non-violent offender, and he pleaded guilty to 4 low-level charges: disorderly conduct, parading in a public building. So he doesn't have an obstruction of justice charge. It's just disorderly conduct, and he was in the wrong place. He was parading in a public building, and Judge Lambert, this is one of the swamp judges in D.C., decided to give him prison for the low-level charges, for the misdemeanors, and then just to tack on a lengthy period of probation, essentially extending out to the next election. And the judge was actually very candid about why he was giving these 2 sentences. He basically says, number one, he says that he's giving the prison sentence to punish him for the offense. The court must not only punish Little for his conduct, but also ensure that he will not engage in similar conduct again during the next election. So he says only a longer-term period of probation is adequate to ensure that Little will not become an active participant in another riot. So in other words, let's tie his hands and put him under criminal supervision all the way through 2024 so he doesn't get a similar idea then. The only problem with this, and you may say, well, a judge, he imposed a sentence. It may be unfair, but a judge has the right to do that. Actually, he doesn't. Why? Because the statute is very clear. The statute says that for these kinds of petty offenses, we're not talking about more violent offenses or more serious offenses, but for these offenses, you can impose a short prison term, and there are guidelines as to what they can be. Or, says the statute, you can give the person probation. Now, this Judge Lambert probably thought, well, who cares? The statute says this or that. I'm going to give him both. I'm going to give him some prison. I'm going to give him some probation. And here's where the appeals court jumps in and goes, actually, no. Read the statute. When a statute says A or B, it doesn't mean A plus B. It means you choose A or you choose B, but you cannot do both. That's the plain meaning of the words in the statute. So it's interesting reading the decision because it's ultimately a parsing of the simplest type of language that was ignored by Judge Lambert because he probably thought, I'm a swamp judge. I can do whatever I want. These people are enemies of the state. The law says A or B. That's okay. I'm going to give him a little of both and see if I can get away with it. And I'm delighted to say he's not getting away with it. Basically, the majority writes that the text and structure of the relevant criminal code show that, quote, probation and imprisonment may not be imposed as a single sentence. Quote, this is Judge Walker writing for the majority, they are separate options on the menu. In other words, if you choose this for your entree, you can't also choose another entree. This is one of those prefix deals where you get to choose one or the other. Now, the implications. Lots of January 6 defendants have faced this kind of dual sentencing, twisting the statute, and the beauty of knocking it down. Now, admittedly, the DOJ can appeal it, I guess, to the Supreme Court. That would be the ultimate step. But I don't think they're going to get very far with that. The statute is actually reasonably clear. And so this might mean, and I hope it does mean, that lots of the January 6 sentences are modified or even vacated because they are illegal. They are not allowed by the statute under which they were imposed. So this is at a time when we're dealing with a twisted judicial system, twisted judges, twisted juries. It's really refreshing to see that the court itself, and in this case, it's not even the Supreme Court. This is an appellate court in a 2-1 ruling, pushing back. Now, there was a dissent, and the judge goes, well, there's a lot of flexibility that statutes typically give judges and so on. Yeah, there is flexibility, there is discretion, but the discretion is within the bounds of the statute itself. And here, when you read the statute, it's really hard to see what they're talking about, because the statute essentially says that the crime is a minor crime. So you kind of have two options. You can say, listen, I'm going to impose a punishment, and then that's it. You paid for your offense, move on with life. Or you can say, listen, I'm not going to give you that punishment. I'm not going to sentence you to prison, but guess what? I'm going to put you under supervision instead. You're going to get probation instead of prison. And here the judge decided, I've got two motives. I kind of want to punish him, and I want to tie his hands through the 2024 election. So you can see again how election interference is always on these people's minds. It's on these people's minds when they go after Trump. It's on their minds when they go after January 6th defendants. And this little bit of sharp pushback from the DC Appeals Court, I think, is really a breath of fresh air in an otherwise fetid and dank environment. If aches and pains are your problem, Relief Factor is your solution. Debbie and I started taking Relief Factor a couple of years ago, and what a difference we've seen in our joints. Nothing short of amazing. Aches and pains are totally gone thanks to this 100% drug-free solution called Relief Factor. How does it work? Relief Factor supports your body's fight against inflammation that's the source of aches and pains. The vast majority of people who try Relief Factor order more because it works for them. Debbie's a true believer. She can now do exercises that for a long time she wasn't able to do. It's been a real game changer for her, her aunt, other members of our family, Mike here in the studio, and for many other people. You too can benefit. Try it for yourself. Order the 3-week quick start for the discounted price of just $19.95. Go to relieffactor.com or call 800-4-RELIEF to find out more about this offer. The number again to call, 800-4-RELIEF, or go to relieffactor.com. Feel the difference.